So I salute you all. By name I'm Matalo Simon Peter, a learning colleague, and basically today's topic, it is all about marriage. Marriage as in its entirety. You get marriage. So we have like 6 categories of marriage. We have customary marriage, we have the civil marriage, we have the Islamic marriage, we have the church marriage, we have the Hindu marriage. But however, for us, we shall emphasize more on what kind of marriage that is familiar in our concept or in our laws, basically, or in our practices in Uganda. So basically, we shall start with, before when you are married, you first define what is a marriage. As earlier is discussed in one of my recent clips, the definition of marriage was highlighted in the case of Hyde versus Hyde. But remember, under Hyde versus Hyde, the definition is, it is the union, it is the voluntary union of a man and a woman for life, to the exclusion of the rest of the world. But however, I say that definition is not conclusive. Because if it is the union of a man and woman for life, which means it doesn't provide space for what? For divorce. It is a guarantee that you have to be together for what? For life, which is not true. We all know that divorce happens, and divorce is what? Happening, which means the union cannot be what? For life. You get. But however, that's the case of Hyde and Hyde that brought out one of the what? The definitions to mean by what? Marriage. And basically there's a case of Corbett versus Corbett, the union of a man and a woman, they must be of different what? Sex. You get. And our constitution provides that you must be the age of what? Of 18 and above. However, for customary, they say that you must be 16 and what? And above. However, though the customs is conflicting with the grand norm, but however, under the constitution, it provides that we have to practice what? Cultures. If a culture provides from 16, which means the constitution cannot go against it, or it is not repugnant to the constitution. So basically, we shall start with the civil marriage. Civil marriage. Basically, I'll emphasize more on the preliminaries. Preliminaries, they are like the gist that must make the what? That civil marriage to be what? To be valid. You get the preliminaries of a valid what? Civil marriage. So when you go further, first of all, under civil marriage, this is the marriage that is conducted in the registrar's office. You get, that is a civil marriage. It is conducted in the registrar's what? Office. Many people say that it is conducted in court. It is conducted in the what? In the registrar's what? Office. That is civil marriage. One of the preliminaries that I'll start, it will be with residence. You get residence. For a marriage to be valid, when you read section 6 of the Marriage Act, it is the one that describes the residence. It states that one of the parties to the intended marriage is required to give notice to the registrar of the districts in which the marriage is intended to take what? To take place. You get. And also one of the parties has resided for at least 15 what? 15 days in that particular what? Residence. You get. Hope you are clear. That is one of the first preliminaries of a civil what? A civil marriage. That is residence. When you go to another one, it is publicity. You get the publicity. Here we see that when you read section 9 of the Marriage Act, you get section 9 of the Marriage Act provides that upon the receipt of a marriage notice, the registrar, remember we are under civil marriage, and I told you that civil marriage is conducted by what? By a registrar. Upon the receipt of the marriage notice, the registrar shall cause it to be entered in the book to be called the marriage notice book. You get, which may be inspected during office hours without fee. That is about publicity. You get? First of all, the receipt of a marriage notice must be put in the marriage notice book, following section 9 of the Marriage Act. Then also, we see that the registrar shall publish the notice by causing a copy of it to be affixed on the outer door of his or her office, and to be kept unexposed to door until he or she grants his or her certificate under section 10 of the Marriage Act. And it shall be there and for 3 months, until 3 months elapse. You get? 3 months elapse. Actually, those that have got time to go to the High Court, when you look at the registrar's notice board, realize that the notices are always there. You get? The notices are always always there. So the essence is on you, on the registrar, to put it on a notice board for someone to come there and investigate. You get? So if you have any queries towards the same, you can put a caveat, and this caveat you put it under section 13. You get? The caveat can be entered. Section 13, caveat may be entered against the issue of the certificate, whereby for you just have to do what? You just have to go to the notice board and you put objection. You put an objection. You put an objection. So basically that is the essence there. You can lodge a caveat once you are dissatisfied, or you have a reason as to why you must stop that marriage to move in place. You write objection, and you'll be forced to come in court to give your reasons. Now that's why the issue goes to court. You give the reasons as to why you are objecting the marriage. You get? You give your reasons as to why you are objecting the marriage not to take place. As we see various conditions, you get? Whether it was in an existing marriage, any situation that we shall see further, or any condition that we may see that those people are not fit to get married. Failure to present your genuine issue. Actually, here it deals that once they feel that there is a genuine issue, court will prohibit that marriage. You get? And once they feel that your issue is not satisfactory to prohibit the marriage, the court will give a green light to the marriage to take place. And there the marriage cannot be stopped. Once court gives a green light for you, you cannot again appeal against the court decisions. You get? So that is the essence there. You get? The notice must be published for 3 months on the notice board. So there is a question that comes in this essence that once the 3 months elapse, you get? Once the 3 months elapse and you want to lodge a caveat, can you really go there and your caveat becomes valid, or your objection? The rule is once the 3 months elapse without an objection, however much you have a genuine issue, however much you have a burning issue for your objection, court cannot stop the marriage to take place. And another essence here comes in a way that, take for instance, you are in Mbale, the marriage is taking place in Kampala. You get? The 3 months are still on, and you call the registrar, you tell him or her that the marriage, I am objecting it, what and what, because of this and this. Can the marriage be still stopped because you make a phone call? The answer is no, the marriage cannot be stopped. The only procedure that is standard, you must come and put objection on the notice board. And you will be forced to be presented in court to give your reasons as to why the marriage must not continue. You get? Hope we are clear on the issue of publicity. Then we have also age. Under the Constitution, Article 31, it provides the age of 18 years and above. You get? But however, as told you as a disclaimer, under the Customary, which is the Customary Marriage Registrations Act, Cap 248, it provides that the minimum standard age, when you read section 1, Section 11, it provides that the minimum age must be 16 for a female and 18 for the male. You get, hope we are clear on this. 16 for a female and 18 for the male. So that is to deal with under customary. But for civil, you must be 18 and what? And above. Then we have the decree. The decree of marriage. The decree of marriage, it is provided under Section 10 of the Marriage Act, and which provides that the parties must not be within the prohibited degrees of kinship and consanguinity, any blood relationships, or from affinity and the relationships by what? By marriage. That is Section 10, the decree of marriage. When we remember the famous case of Bruno Chiwuwa versus Ivan Serunkuma and Juliet Namazi, you get, realize that their marriage was declared void because it was within the prohibited what? Decree. You get, under this case we see that the High Court barred the respondents from getting what? Getting married on the basis that it would violate the local marriage customs of their what? Of their tribes. You get, because Namazi and Bruno Chiwuwa, and Serunkuma. Bruno Chiwuwa was the father of Namazi, but when you realize that Serunkuma and Namazi, they were all from the clan of what? Endiga clan. You get, so they couldn't get married since they are same what? They are same clan. That is to do the decree of what? Marriage. It is also key as a preliminary under what? Marriages, under civil marriages. Then we also have consent in marriage. Consent marriage is more so vital. It is vital. Whereby when you realize that under consent, Article 31 of the Constitution provides that there must be free consent. And when you read Section 17 of the Marriage Act, it requires a written consent if either the party of the marriage is below the age of 21 years. 21 years, you must have a written what? Consent. If a party is below the age of 21 years. But above, it must be an implied what? Consent. Basically, not an expressed consent. You get? And similarly, even under customary, it provides for consent. When you read Section 32 of the Customary Marriage Registrations Act, provides that there must be consent of the what? Of the parties. And under consent, we have the case of paragesic versus paragesic, 1959. Paragesic versus paragesic, it was held that although the petitioner had not understood the nature of the ceremony, it had established that she never consented to the marriage, but was driven to go through the ceremony by terror instilled in her by her father's what? Threats. Therefore, a decree of nullity was granted. You get, here the defendant went through marriage under the threats of the father. You get, so he brought a petition that there was no consent, although the ceremonies had been what? Passed through. But he made the ceremonies under the consent of what? Under the threats, under the terror of the father. Then we have also notice. Section 6 of the Marriage Act. It provides that one of the parties to the intended marriage is required to give notice to the registrar. You understand? This is civil marriages. You must notify the what? The registrar. Then also another preliminary says that neither party is already married to some other person. You must not be in some other what? Marriages. That is Section 34 of the Marriage Act. You must not be in another what? In another marriage. You get? And we have the case of Ayob versus Ayob. Ayob versus Ayob, the petitioner and the respondent, both they were Muslims, were married under the Marriage Act of Kenya, and subsequently went through a marriage according to the Islamic what? Islamic principles of the Muhammadan what? Law. The petitioner husband later divorced the respondent by talaq. You get? But however, he realized that he wanted to enter into another what? Actually, he divorced the husband under talaq. Remember, talaq is under the characters of Islam. But however, these people had gone through marriage under the Marriage Act, not under the Quran. You get? So divorcing the wife under talaq wasn't valid because the marriage was under the Marriage Act, not the Quran. So he married another person, and he also claimed that for them Muslims, they can marry more than one wife. But remember here in this essence that the person that he wanted, the marriage that he had attained at first was under Marriage Act, of which the Marriage Act says that you must have only one wife. Their court held that he couldn't get married to another person. He could pass the right procedures of divorce under the Marriage Act of what? Of Kenya. That is the case of Ayob versus what? Ayob. So basically, those are some of the plenaries of civil what? Civil marriage. Then when you go to church preliminaries, that is church marriage, under church marriage. Church marriage is marriage conducted in what? In church. Well, actually, this is the most relevant marriage, familiar marriage that we all know, that marriage must be in church. You get? So basically, first of all, some of the things are similar to the civil marriage, but however, there are some that differ. First of all, the church marriage, when you read section 20 of the Marriage Act, provides that it must be celebrated in any licensed place of worship by any recognized minister of the church, denomination or body. Remember, we all know that not every church can conduct a marriage. We all know that. So that church must be what? Must be licensed. And the license must be from the register of what? Marriages. So that is section 20 of the Marriage Act. When you read some of the plenaries, you have also residence to deal with the church marriage. Actually, under residence, it says that if the parties are residing in the same parish, the banns must be published there, and if they are in different parishes, there in each of their different churches, the banns must be published there. Let me give an example. Take an example. If I'm from the parish of Lubaga, I'm giving you an example. Parish of Lubaga, and someone else is in the parish of Boyogerere. You get? So if we are all, if we want to get married in the parish of Lubaga, me, the parish that I reside from, which is Boyogerere, also the banns must be what? Must be published there in Boyogerere and Lubaga. You get? But if it is of great advantage as whereby we are all in the parish of Lubaga, then the banns will be published in only what? The parish of Lubaga. But if we are from different parishes, then we are all supposed to publish those banns in the different what? Parishes. You get? And also when you read section 10 of the Marriage Act, it says that at least one of the parties to the marriage must have resided in that parish which would be celebrated for at least 15 days. They now. That is to deal with residence. You get? So when you go to publicity is that those banns must be read in church for a period of 3 what? So 3, basically they must be read for a couple of times, whereby we say that we attend church and the reverend or the father, they read that you have a marriage, so and so, anyone that has a query, please put your query. They must read, is it 3 times? 3 times in the church. So failure to bring any objection, then the marriage must be what? Conducted. Under still publicity, the people must use their exact names on the banns. If you use a wrong name, your marriage can be declared what? A nullity at the end. You get? So under under publicity, we have the case of dancer versus dancer. Under the case of dancer versus dancer, we realize that there's a lady that was called Jasmine. Jasmine was a legitimate daughter to the Miss and Mrs. Knight. When Jasmine was aged 3, Miss Knight began to do what? Began to live with Mr. Roberts. Miss Knight began to live with Mr. Roberts, by whom she had children. Then all the children, including Jasmine, were known as Roberts. You get? So Jasmine got the name of what? Roberts. Later, here we realize that when the petitioner petitioned for a decree of nullity, arguing that the undue publication of the bans, that the name that was indicated was wrong, the court held, remember this Jasmine used Roberts, because when his mother went to live with Roberts, he also got the name of Roberts, though he was Knight. You get? So it was held by the court that there was no undue publication given the fact that she adopted the advice of the vicar, what? The vicar, for using the name of Roberts on her bans. Reason being that the name Roberts, it's what people knew. You get? He couldn't use the name Knight, because the name of Knight, people didn't know it. So he used the name of what? Roberts. You get? Which people knew. So court held that they couldn't declare his marriage what? A nullity. Hope we're on the same page. Then there's a case of small versus small, still under publicity. Small versus small realized that the defendant was a deserter from the Royal Field Artillery. In order to avoid detention and prosecution, he assumed a false name, which he used in the relation to the publication of bans concerning his marriage to the plaintiff. You get? Then it was held that the fraudulent intention to conceal his identity, the marriage bans, had not been properly what? Published. The marriage was therefore void. It was declared a nullity because he used false names on the what? On his or her bans. Here the bans must have your right what? Names. Then you go to sex. Under church marriage, you must be of opposite sex. The case of Corbett versus Corbett. You get? Under the case of Corbett versus Corbett, the plaintiff and the defendant participated in marriage ceremony in 1963. In 1960, why actually the defendant was born a male. You get? But he had undergone a sex change surgery after he was lived as a woman. You get? And where he got the plaintiff from. The court said that the so-called marriage between the defendant and the plaintiff was void. You get? Because the other one had gone what? They call it what? That surgery became a woman, which was ironical. So the marriage was declared what? A void. And court said that the marriage must be between what? Opposite sex. Then we also have the case of Talbot versus Talbot. Talbot versus Talbot. The case of Talbot versus Talbot, a woman had dressed herself as a man and went about calling himself what? John. Herself John. Yet he was a woman. She managed to get herself a woman with whom she celebrated what? A marriage. Remember, he was a woman. He called herself John. Then he got a woman and they celebrated the marriage. The next day when the woman discovered she had married a fellow woman, you get, she didn't seek for nullity to the union. Therefore, but continued to live what? Living together for 4 years. They lived together. But this lady knew that she had married what? A fellow woman. But she didn't ask for nullity. But they lived together for 4 years. Then afterwards, she petitioned to court to declare the union of what? Nullity, which was granted by court on reasoning that there existed no marriage from the start. The marriage was void ab initio. There existed, however much he spent that 4 years without notifying court, court held that the marriage was void ab initio from the start. We shall see void and voidable marriage. You get? And for marriage bans under church must be announced 3 times. 3 times in church. You get? They must be announced 3 times in what? In church. Failure to come any objection, the marriage must be what? conducted. You get? So that's to deal with what? That we have seen civil, we have seen what? We have seen civil, we have seen church marriages. You get? Then we shall go to customary what? Customary marriages. When you go to customary marriage, for it, as I told you earlier, that it also deals with what? With age. For it, its age. When you read with age, section 11 says that a female must be 16 years and a male must be 18 years. For consent, it is under section 32 of the Customary Marriage Registration Act, whereby they say that there must be what? Consent. You get? And for customary marriages, basically for them they are polygamous. That's the general rule. For them they are what? Polygamous. You can marry more than one what? One wife. When you read the case of John Tom Chintu versus Miliasius Gafabusa Chintu, that is Chintu versus Chintu, realize that it stated that if a person married under customary law continues to marry more wives under the same type of marriage, he does not commit adultery. You get? That was what was stated in that what? In that case. You get? So, and also under the case of Uganda versus Peter Kato and 3 others, it was held that the test of determining what a marriage is under customary law is whether the union is treated as marriage by the laws or customs of that what? Particular nation, race or sect to which the parties what? Belong. You get? Hope I'm clear there. And some of the preliminaries under customary marriage, we have bride price. When you read the case of Mifumi versus Anthony Jenu, bride price is what? Is key. You understand? You have to provide bride price. Mifumi versus Anthony Jenu. And another one is consent, as I've told you before. That is section 32 of the Customary Marriage Registration Act. That is consent. We have the case of Pomela Sabina Mbabaz versus Henry Mbazira. You get? The Court of Appeal understood the necessity of what? Of the couple's what? Consent to marry. It must be very, very vital. So with the age, we have seen the age and the prohibited decrees. That is also key. That is Bruno Chihuwa versus Serunguma Namazi. We have seen that case. When you read prohibited decrees, they are under section 11 of the Customary Marriage Registrations Act. That is, and also the second schedule of the what? Of the Act. You get? That's to deal with customary what? Marriages. Then when you go to Islamic marriages basically for them, they are valid, they are provided, they are under the Quran, whereby for you have to give what they call a mahari. You get a mahari. A mahari they are given to the wife. For that marriage to be valid, you must have provided for mahari to the wife, and also bride price to the what? To the parents, and also consent must also be there. You get? Under the Islamic what? And Islamic marriage, they are also polygamous. You can marry more than one what? One wife. You get? But however, once you have decided to, and to sum up everything is that once you have decided to marry in a particular type of marriage, you cannot marry another person in another marriage. Take for instance, if it is Islam. Islam says that it's polygamous. You cannot marry one wife under Islam, and you say that since Islam is polygamous, let me marry another wife under church marriage. It is prohibited. When you remember the case of Ayob versus Ayob, if you have decided to use the Marriage Act, stay monogamous. If you have decided to use Islam, follow Islam, but while using polygamous what? Marriages. You get? So, thank you for listening. Like my video, subscribe. I wish you the best. I remain Matalo Simon Peter. Thank you very much.